We're here talking about Bill C-11, which is before the House, which is termed a new digital Charter of Rights. We're here with Dr. Teresa Scazza, Professor of Law at the University of Ottawa, that's unpacking this with us. Dr. Scazza, I had to cut you off from the last part of your point, if you can finish that, and I've got some more questions for you.
Yeah, well, basically, just to sum it up, I think the government was trying to both make it easier for businesses to make use of data that they've already collected without having to go back for new consent, and also to reduce the consent burden. By rolling those two things in together, I think they may have created some exceptions that are overly broad and problematic. And so I think this is something that we'll need to pay attention to during this process of debate in Parliament.
So let's talk about the subject of consent. So I want to give you an example, and maybe if you can tell me how the new bill will cover off a scenario like this. I think many people might be able to relate. I know personally, over the holidays, I was referring to a board game that I used to play as a child. I probably hadn't even referenced that board game, I think it was backgammon, for 20 or 30 years. And then within 20 minutes, it was on my Instagram feed. How are we dealing with consents and privacy issues? Are companies allowed to listen into what we're saying? And is this something that's being factored into the bill?
Yeah, I mean, this is very challenging because so much of what we do is digital now, and so much information is being collected. I mentioned the consent burden, so we may have consented to these types of collection of information, whether it's recording of voice or whether it's data about our internet habits. We may have consented to it, but we're not aware of it. And so this is one of the challenges of contemporary data protection legislation. How do you protect individuals from abusive uses of their personal information when the personal information is being collected? And so one of the difficulties of a consent model is really the consent burden, the fact that we can't practically control all of the different collections and uses that are made of our personal information because there's just too many and we don't have enough time to do all of that, and it's too complicated. On the other hand, we need to be protected from abusive or exploitative data collection and use practices. There are a few things in the bill that try to limit that. There's the reasonable purposes limitation that existed in PIPEDA as well, and that's been carried over into the bill. Where there are exceptions to knowledge and consent, there are also limitations on how that data can be used in an attempt to further protect individuals. But this is frankly one of the big challenges of data protection laws.
Well, and I think one of the parts of the bill that's being covered off is when can corporations share information with other corporations, and what consent do you need in that area? So of course there's a lot of sharing of information back and forth. How does the bill start to deal with that or limit that in any area?
Yeah, well, there are different types of data sharing, and so some of them will be ones that individuals consent to in privacy policies, which we are challenged in reading. So they may indicate that that data is going to be shared with affiliates or other corporations for other purposes, and those are part of what gets consented to. There are some other exceptions which allow for information to be shared without knowledge or consent, and some of those relate to very specific purposes, and those purposes can include transfers for processing. And this is a practice that takes place all the time now, where businesses transfer personal data to other organizations to perform some of the functions in relation to processing the data. So it's outsourcing of data, and that can, under this bill, will be able to take place without knowledge or consent of individuals.
So an example of that would be if you have a customer service group that is associated with, let's say, one of the large banks or one of the large telecommunications. Your call gets routed overseas, and they're passing information about you over to these third parties. Is that what you're referring to? That
would certainly be an example of a transfer of data for processing. And so then you believe you're dealing with your bank, but there is another company that is providing that particular customer service operation, and they have access to your personal information. Now, under the framework of the legislation, there have to be contracts and other safeguards in place to ensure that your information is handled appropriately. But the complication in today's data economy is that there are many more ways in which, so it's no longer simply another company providing a service for the first company. And this bill actually contemplates that those companies may have their own needs or uses for that personal data.